My name is Scott Smith. I'm the director of the Arkansas Public School Resource Center, and I want to thank you for joining us for round 2 of school board training for 23-24. I also want to thank Mr. Gerald Cooper and Mr. Benny Weston from the North Central Co-op and the DeQueen Mena Co-op for letting us do this training with you again tonight. You see on the slide the topics that we're going to cover tonight. The board governance topics is going to be new Attorney General opinions and some new case law that we think we need to make you aware of and that you might find relevant. I think we're going to look at superintendent contracts and what are some of the performance criteria under the new law that have to be looked at in those, or at least listed in those. And I think that will be Michael Helms and Ken Rich covering some of that. Artificial intelligence, it's a new phenomena for educators and kind of having impact already, and probably going to have a lot more impact going forward. And Jim Robb will be looking at that. Student achievement. We have a video that's being prepared and presented by the Arkansas Leadership Academy on things that you as a board need to look at. So hopefully that will be helpful, and I look forward to answering any questions you may have off of that. And then I think we're also covering audit and financial management. The folks who are with me tonight: Ken Rich, who's our Director of School Finance; Michael Helms, our Director of Legal Services; Tripp Walter, who's one of our attorneys; and Jim Robb, the Director of School Support. And also salary schedules, I should mention, with Ken tonight as well. So thanks again for being with us. I appreciate you all, and we really appreciate the service that you provide to the state of Arkansas for serving as school board members.
My name is Tripp Walter. I'm a staff attorney here at APSRC. I'm going to take you through the board governance part of our training tonight, and also am going to visit with you about superintendent performance targets. I think I'll also have Ken Rich joining me on that presentation. So let's go ahead and get started. The first case, first the new Supreme Court cases we have for you is Perez versus Sturgis. The reason we thought this was important is because it deals with a legal issue that we don't see very often. The facts of the case, which are laid out on your slide, essentially is that Miguel Luna Perez, who is a student who's deaf and attended school in a school district in Michigan. The district advised the Perez family that Miguel was not going to be able to graduate. That caused he and his family to file a state complaint with the Michigan Department of Education, saying that the district didn't provide him with a free and appropriate public education as required by the IDEA, Individuals with Disabilities Education Act. Specifically, that Mr. Perez required assistance from interpreters to get the full benefit of the educational program, and the ones that he received were unqualified. There was a settlement reached on that complaint with the Michigan Department of Education. However, after that, then Mr. Perez sued the district in federal district court under the Americans with Disabilities Act, claiming compensatory damages due to the lack of educational services provided. So the legal point here was that the Department of Education in Michigan argued that under what's called the exhaustion theory of law, that Mr. Perez had a chance to include the compensatory damages piece, and that is put all of his legal claims into one with the initial claim that went against the department. And the Perez family said, no, that's not the case. We didn't have to, so to speak, exhaust everything through our IDEA claim, because IDEA doesn't provide for compensatory damages, money damages. It just provides for additional educational services. And so the Supreme Court held that the Perez family's argument was correct, that in this situation, the exhaustion requirement of IDEA didn't apply because of the fact that they could not get the damages they were seeking under IDEA. The O'Connor-Ratcliffe versus Garnier case, a U.S. Supreme Court decision from April 24th, we think is very relevant because it deals with school members' social media accounts. And essentially what happened here is we had two school board members in a district in California that created social media accounts. And the social media accounts they created went beyond just personal information about them. They used it to push out a lot of information concerning the school district. As time went on, members of the public, namely patrons of the district, started posting on the members' website. And apparently, at least one of the parents, the one that's noted here who posted so many times on the account because they didn't feel they were getting an adequate response from the school board member to their emails, and they wanted to make sure that all the patrons of the district who were also on these accounts, watching the postings on these accounts, saw that the questions weren't being answered. When the problem got to such a point that the school board members felt it was really blocking their ability to keep utilizing the accounts, then they went ahead and blocked the parents from the accounts. The parents filed suit saying this was a violation of their First Amendment because it wasn't a situation they felt that legally the school board members could do this because, again, it wasn't their personal accounts. It had information concerning the school district on it. And so it was more like a government or a school account because of their positions. So the board members said no, there was no state action. It was our personal social media accounts. Nothing we did caused them to ever stop being our personal social media accounts. So this creates a real interesting, we think, legal point as to whether when you are a school board member and you utilize your social media accounts not only for personal information but to promote school business or school activities, whether you have the ability to totally control those accounts. And as you see at the bottom there, the Supreme Court will consider this case at its term starting this month, which means that we should expect a ruling from them probably sometime early part of next year. This case you may have heard of, the Students for Fair Admissions case versus Harvard and the University of North Carolina. What happened here is that suit was brought against Harvard and North Carolina stating that they violated a portion of the Constitution and Title VI of the Civil Rights Act because they impermissibly used race in their undergraduate admissions processes. And Title VI, which requires that all colleges and universities receive financial federal assistance, have to comply with the same requirements imposed by the Equal Protection Clause, which said that consideration of individual students' race in making admissions decisions violated that. The school said it was proper for them to do so because there are a lot of educational benefits that could be had throughout the student body through having a diverse student population. And you see here, those are listed out. The Supreme Court said that those interests were not enough to continue to have race-based admission processes because the various things they noted were really not something that was subject to review. You couldn't measure it, you couldn't quantify it, and so it was hard to determine whether those interests were narrowly tailored in a way to be able to utilize race. And again, failed to articulate a meaningful connection between the means they employed and the goals they pursued. Now, one of the reasons we brought this to your attention is that even though the Supreme Court's decision just talk about higher education, what happens if this decision is taken further or there are similar lawsuits that are brought alleging the use of race at the K-12 level? So what are programs that you have as districts that possibly utilize race in an attempt to diversify student participation in selective activities such as magnet schools, gifted classes, attempting to address equity in grading, discipline, and other voluntary practices. So again, to recap, this is not something that directly affects you now, but we're watching it and we'll keep you posted to see if it extends its reach to K-12 schools in the future. And the Carson v. Macon case, you may remember if you were with us last year, involved a law in Maine which allowed families whose local school districts didn't offer high school grades, and apparently that's relatively common in Maine, being a rural state, that some of the school districts only went through grade 8. Maine provided a program where the family could enter into an agreement with another school district that offered grades 9 through 12, or a private non-sectarian, meaning non-religious school, to offer those grades, and in either event, the state would be responsible for paying whatever tuition and fees and expenses dealt with that. The family, the plaintiffs in Carson v. Macon, had a student that was going to be able to avail themselves of this because they lived in a K-8 district only. However, they wanted to send their child to a private school that was religious in nature. And what the Supreme Court held in this case is that because the tuition program that Maine had was basically a public benefit program, then the fact that Maine tried to limit participation or getting on the approved list to only non-sectarian, non-religious private schools violated the federal Constitution. So why we brought this to your attention last year and wanted to bring it to your attention again this year, the relevance here is as we're talking about issues of the state's allocation of public funds to private educational entities to educate students, such as vouchers and scholarships. The other Supreme Court case from last year we wanted to bring your attention because it's of a special relevance to you is the Kennedy versus Bremerton school district case. Bremerton's a school district in Washington. This one you may remember because it involved a football coach for the Bremerton school district. And the football coach routinely, after games and after finished visiting, doing any post-game wrap-up, so to speak, with his players, would go out to midfield and the 50-yard line and take a knee and pray. And he did not attempt to have any of his players join him or anybody else. They were free to do so, but he never forced or coerced anybody to do it. So the district eventually took disciplinary action and fired him because what they felt was improper behavior, promotion of religion. Case went all the way up to the U.S. Supreme Court, and the Supreme Court said no, that it was a violation of the free exercise and free speech clauses of the First Amendment, because the coach was doing the praying on his own, was not including anybody else involuntarily in the process, and that was a proper exercise of his religious freedoms under the Constitution. In other words, he wasn't trying to coerce anybody to join in prayer with him, to try to proselytize them, to get them to be of the same religious mindset as him, etc. Federal District Court case in Arkansas. What happened here is last year the Cabot School District notified Ms. Bosch that she was barred from all Cabot Public School property unless she called 24 hours in advance. And this was due to comments that she made at a meeting, not a school board meeting, not on campus, last June, threatening school district staff. That prompted Ms. Bosch to file a lawsuit against the district in federal district court, and then on July 13th of this year, the school district filed a motion for protective order, and here's the important legal point here, is what Mrs. Bosch's attorneys were trying to do in trying to get discovery, that is evidence from the school district in her case, is she was attempting to use the Freedom of Information Act as a way to get that information and kind of circumventing what the usual discovery process. And the attorneys for the district pushed back saying it's not proper for her to utilize FOIA to get at our work papers, at our attorney-client privileged material. So where this stands now is on September 14th there was a hearing, and there's a stay in place for the next 60 days to prevent Ms. Bosch and her attorneys from getting any information about that she thinks would further the lawsuit through FOIA. So we'll keep you posted on this one, as again, this could have wide-ranging implications. Going on to our Attorney General opinions, the first one deals with the situation we deal with from here on a relatively regular basis, and that is dual office holding. So the question was asked the Attorney General here was, could a county justice of the peace be elected as a member of the school board of directors while still maintaining the office of Justice of the Peace? And so the Attorney General got into the discussion of dual office holding. Specifically, it said there are certain county offices, and they're listed on your slide there, as well as being a school board member, which constitutes being appointed, elected to a civil office in the state. And so as the seat on the school board would be considered a civil office, that would mean the Justice of the Peace would be in violation of dual office holding because he was going to hold both positions. Now, it's important here to notice how this works. There are other Attorney General opinions, which you're probably more familiar with, that talks about it from the other standpoint. That is, you're a school board member and then you want to seek county office. So generally that's going to be permissible if it's not a situation where that county office would have some kind of control over the district. So an example of where that could be a problem is Justice of the Peace, for example, because of tax revenues. The next Attorney General opinion, 2023-027, is reinforcing the fact that executive sessions cannot be allowed to discuss cybersecurity for school districts. So in this case, the Little Rock School District asked the Attorney General opinion if the school board could meet privately or in executive session to discuss how to deal with the cyber attack situation they were under, and alternatively, if they couldn't, could they videotape the meeting and then post it for viewing? And the Attorney General said no to both because, again, the FOIA law does not allow executive sessions to discuss cybersecurity. And you also may remember the discussion that Scott had with you in session 1 concerning FOIA in general and executive sessions. This one I put in here because I have reason to believe in my work throughout the years that the folks in your district sometimes run across a situation where somebody makes a request for an employee or a former employee's records. And of course, in that case, you have to notify the employee or former employee, give him or her a certain amount of time to be able to make a FOIA request, a request to the Attorney General to keep the records from being disclosed. And in this case, that's the situation we had here, but the requester objected and filed an Attorney General's request, opinion request, to keep the records from disclosure, stating that he didn't know who the requester was, nor did he know what the requester plans to do with them. And the bottom line is this, that under FOIA, it doesn't make any difference for what reason the requester wants the records, and it doesn't make any difference whether you know the requester. You still have to make a decision whether to release the records based on the law. And again, go back to Scott's discussion with you as FOIA in this situation on the first meeting we had, session 1. This Attorney General's opinion 2023 is interesting because a lot of you are probably considering the building and construction of storm shelters, and one of the things you have to do in determining that is how big does it have to be. That is, in the appropriate rules governing it, how many how many folks must it be able to handle? So the Attorney General's office got a question on that it was asking, okay, so how do we figure that out? Do we go by what's in the fire code? Or do we go what's in the DESE rules governing class size and teaching load? And which one of those controls? I'll leave the rest of it to your reading on the slide here, but the short answer was this, is the Attorney General came down on the side of, all right, the purpose of the DESE rules is to determine space of a classroom. What's an adequate size of a classroom for teaching purposes? The fire code's occupant loads are meant to address the number of individuals who could safely occupy a given space. So the Attorney General's answer was no, that the district could not use the class size and teaching loads to calculate occupancy. All right. There was one other Attorney General opinion that I wanted to bring to your attention, and that one has to do with the Bentonville School District. And essentially what happened here is the Bentonville School District saw an AG opinion because they were seeking to donate approximately 9 acres of land on their campus to a not-for-profit organization in order to enable it to construct a community center which could be used by members of the school district, and also housing, at least some of which would be dedicated to providing low-cost housing for teachers. The backdrop of this is there's an Arkansas law 6-21108, which talks about abilities that instances in which public entities, such as school districts, can potentially donate surplus real property. It has to be for specifically set out purposes in the statute, and it has to be to specific entities. And so a lot of the opinion dealt with whether the Attorney General felt that this donation fulfilled those requirements. The main reason we wanted to bring this to your attention is this. The usual law in this case, or the standard law in this case, you probably know, is if you're going to dispose of your surplus real property, you're going to have to get fair market value for it. Now, 621-108, we wanted to bring your attention, has never been tested in court. Okay? So we don't know if that would hold up as a valid reason, but we wanted to emphasize to you the importance of considering what the usual law is in this area, and also because there are legal issues to deal with in this area, we advise seeking advice from a professional appraiser, perhaps legal counsel, as to what is the best way for you to handle the disposal of your surplus real property and what kind of return you should be getting from it. Because again, your real property is just like your money, right? It's school property, it's school funds dedicated to school purposes. Other issues you may have to consider too when you're looking at disposing of real property is that attached to any bond issues? So is there any possible lien issues that go along with that? The final thing I want to cover, and I think Ken's going to jump in remotely on this, is superintendent performance targets. This was a portion of the LEARNS Act, and what it did, I'm going to skip a slide for a minute, it became effective on July 1st, but essentially what it did is it set forth a requirement, I'm going to go back to the slide, that requires the employment contract of district superintendents contain information about the following performance targets. Now it says without limitation, so others could be added, but these we're showing you with the bullet points on the slide are what's required. And this is going to apply, as we'll see on this slide, to any superintendent's contract which is executed, negotiated, or renegotiated after July 1st, 2023. If a contract after July 1st of this year, which is executed, negotiated, or renegotiated, does not contain those requirements, then it's going to be null and void, meaning it's going to be of no effect legally. Okay? The new law also requires that you have to post the employment contract on the website and submit a copy of the contract to the Commissioner Desi. However, we have heard, and you see at the bottom there, rules are going to be promulgated on this. They have not been promulgated yet. It may be that just the posting the contract on the website will be sufficient and may not require submitting a copy of the contract to the Commissioner Desi.